when you look at the rules, and we look at the rules over the course of the last 45 years and the way they've changed, the way that we market changes significantly. The concept of the consumer is supposed to be number one, but in reality, they don't complain because they know it's commercials, they know it's advertising, they know it's marketing, okay? They know what it is. And different types of sanctions, you gotta be really bad to get in big trouble. You know, most of the time, if it's a first offense, you fix it and you don't do it again. If it's a second offense, definitely don't do it again.
My name is Nina, and I'll be the moderator for this webinar. I wanted to start out by giving a bit of background on our speaker, Micah Buchdahl. Micah Buchdahl is a Pennsylvania licensed attorney assisting law firms and business development initiatives. Based in Morristown, New Jersey, he is president of HTM Lawyers Incorporated, a law marketing consultancy. Micah is known for his ethics counsel as it pertains to law marketing, advertising, and compliance. He is a member of the Association of Professional Responsibility Lawyers and a past chair of the ABA's Law Practice Division. Micah attended Temple University for both his BA and JD. The webinar presentation you're about to see will be approximately 1 hour, and Micah will be taking audience questions after the presentation is complete. So if you have any questions for Micah that come up during the webinar, please place them in that Q&A button that's at the bottom of your screen. Without further ado, here is Micah to discuss law marketing ethics issues in a race for clients.
Thanks, everybody, and thank you, Justia, for having me. For the next hour, we're going to talk about legal marketing ethics in the race for clients. One of the things that I find so interesting about this subject matter is I've been teaching it for over 20 years and it never gets old and it changes constantly. And so here we are in 2023 and it's just as new as it was when I first started talking about it in the late 90s. So on one side of this slide is the ad from Bates v. Arizona in 1977. And so 2 young guys getting out of law school, wanting to market a practice, hang their own shingle. And so they go and they want to basically put out this very benign directory ad until they find out that lawyers aren't allowed to market. And so that doesn't work until, again, 1977, when that ad was basically approved. If those 2 guys were graduating from law school right now, and figuring out a way to hang their own shingle and get started in terms of marketing, I highly doubt they'd be concerned about a directory ad, but they'd probably be looking to figure out how to get on a TikTok and market themselves that way. So that's just when you look at the rules, and we look at the rules over the course of the last 45 years and the way they've changed, the way that we market changes significantly. Many of you in California are probably familiar with Miles and Top Gun DUI. One of the reasons that I always go back to this website is it was displayed at the very first internet marketing ethics program I ever attended, probably around 1996, 97. And this was put up, this is the new website, but his old website was put up, and it was put up in this in this ethics presentation as this how terrible it was, the way that lawyers were marketing themselves, and whether or not what he was doing was ethical. And the thing is, what he was doing back then and today was ethical. It was different, and it was innovative. And like my friend Greg Siskin in the immigration law practice with visalaw.com, they were first movers. And so I go back and I look at some of the components of Miles' website today. It's obviously a lot more vibrant. It's got video, all kinds of other things. But I still am entertained by his Friends Don't Let Friends Plead Guilty trademark that's been out there for a couple of decades. And then the content on there, for example, the long list of people's blood alcohol levels and not guilty that's portrayed that's put out there. And it's just a reminder that again, some of these folks that were out there early, it was maybe offensive to some, but in reality, they're the ones that have actually prospered and grown over the course of time. The other thing that we look at is the way that people advertise today, and it's not, we don't advertise in traditional ways anymore. This is an attorney who basically, advertises on Uber and Lyft cars in Florida. And so one of the things I find interesting about her practice is that she also represents people that get in accidents. So I just imagine that you're in a Lyft, you get in an accident, you get out of the car, you call the phone number, and you begin suing whomever it is that was driving you. So, but the question ends up being, like what is that ad? Okay. The ad on the Uber. Do you look at it as simply the exact same as a billboard, and you have to follow the rules of billboards in this case, Florida, which would mean having pre-approval of the ad. So it's about being creative in the way that you market yourself, and then the issues that come up. So the title of this program really comes from, from an Amtrak crash from last year, and I was just amazed. I mean, it's a little bit morbid. What I do is, I see an accident occur. I'm on my desktop. I see something bad happen, and I think about the litigation that might spring from it. And then I immediately go out and look to see what lawyers are already out there in that space, sometimes minutes after the accident occurs. And so this Amtrak train crash, if you remember this crash in Missouri last year, of this train traveling from LA to Chicago. Okay, it derails at 12:43 p.m. The accident occurs. By 5 o'clock that day, there were already attorney websites up for that specific accident. And by 9 a.m. the next morning, clients had already been retained as a result of those websites and the marketing that's done. The example that I have up here on the screen captured are a couple of press releases from a law firm in Chicago, again, announcing, basically talking about the accident and then talking about retaining a client the next day. And so, it reminds you about how quickly you need to move in some of these circumstances and some of these situations. I call it fast mover advantage. Okay, so what is it? This is another, terrible example, right, of a horrible accident in New York, a helicopter crash. These guys were like basically live online, showing, thumbs up and happy as could be, portraying their helicopter ride 1 minute and unfortunately in a deadly accident the next. And so what happens when, somebody sees these types of situations or accidents occur? So what are some of the things that you do? Okay. If you're a plaintiff's attorney and you work in this space, and by the way, the things that I talk about in this hour will cover every type of law firm and every type of practice in every type of jurisdiction. But in this case, talking about the aggressive nature of some plaintiff's practices, what are some of the things that people do the second that they see one of these accidents happen? They go out and they buy domain names tied to the accident itself. They buy AdWords and pay-per-clicks immediately before the price goes up. They create focused SEO pages. They issue news releases about the accident. They might hold a press conference. They target on social media various messages. So all these things that are done sometimes within minutes, if not hours, of the accident occurring. And it just is a reminder about how fast you need to move. There are other tools that are out there that you may or may not be familiar with, and you may or may not like them. But terms that people utilize in terms of, aggressive styles of digital marketing. The term newsjacking, which is injecting your ideas into a breaking news story and then generating media coverage and social media engagement from it. Geofencing, location-based marketing, creating a virtual geographical boundary and triggering a targeted marketing action. So areas that are often geofenced include, hospitals and emergency rooms and accident sites. Those are places that are geofenced. The concept of remarketing and retargeting. Remarketing refers to engaging audiences who have already interacted with you using collected email addresses. And then retargeting, I'm going to show you an example of retargeting in a little bit later, but using cookies to place ads in front of prospective clients. The concept of OTT and CTT, delivering to viewers in lieu of cable and broadcast TV, streaming ads, and CTV placing them alongside apps and shows on a connected device. So, just those, as opposed to regular TV commercials. Regular TV commercials can be very difficult for people now, right? Because, I watched the Oscars the other night. I purposely turned it on an hour into the show. I then fast forwarded through every commercial and any award I didn't care about. Okay, so so I didn't see a single ad that was put in front of me. When I watch Hulu, which I don't pay for the ad-free Hulu subscription, all of those ads that I cannot fast forward through, that I have to watch, are often dished up to me based on something in my demographic, an audience that they're trying to reach. It's very targeted and it's a lot more effective. And then I'm not really going to talk about ChatGPT. It's in the news all the time now. There's a great article from Marina Justia that's on the ABA Law Practice webzine site today about the use of ChatGPT. It's very hot, and it's led to a lot of potential ethics issues. I had a digital marketing person the other day come to me. We were talking about the online chat on a law firm's website, and so we're going through the chat. And somebody had complained that the answer that they were receiving in the chat wasn't proper. Okay, it wasn't profane, but it wasn't right. And so we're going through the chat, and I said, is this a live person? Because it says I'm talking to a live person. And then the guy says to me, well, I'm not sure. Okay. So, I wasn't sure that it wasn't a bot answering my questions. And so, so I think as this technology progresses and lawyers use it more, there are a lot of ethical issues that could come out of it. And we're going to talk about some of those things dealing with AI in this hour. Other components of marketing that doesn't necessarily always fall into the advertising realm are press releases. And so in one example up here, this is from actually the Amtrak crash in, I believe, 2016. And that was a deadly crash in Philadelphia. And so again, like a law firm puts out a press release saying that they're accepting train accident cases. Now, I started my career as a PR guy. Okay, I used to issue press releases all the time in pro sports. And that's not news, right? Like, I'd get yelled at if I sent a press release in that way to, the Washington Post. Because they'd be like, that's not news. Okay. And so the question is, are these press releases advertising or are they news? And there's some states that look at a press release. And sometimes, when I send that press release directly to a journalist, it is not advertising. Okay. I can be flowery. I can boast. I can say whatever I want. And the journalist can sit there and look at it and go, that guy's blowing smoke. Right. But if I put that exact same press release on my law firm website, then it becomes part of the website and it becomes advertising. On the other side here, I have Firm News. That's basically the use of PR Newswire, which is, again, a very effective way of getting found online, is using PR Newswire. And that's a real gray area between whether or not it's advertising or whether it's not. Most of the time, you're going to be able to effectively argue that a PR Newswire press release, which is very effective and comes up very high on a search engine result, is not going to be deemed a press release. But it's another way of generating attention and traffic, and it's an area that's not cut and dried in regard to its promotional value. Press conferences are an area, especially in this space, in dealing with the race for clients, that always kind of bothers me, because when a lawyer goes right to an accident scene and holds a press conference, that to me goes against the whole concept of the solicitation ban and what you are and aren't allowed to do. Yet, if it's considered a press conference, okay, most people do not consider it advertising, but it's another way that a lot of attorneys use as a tool sort of outside the regular marketing realm to generate attention and generate traffic. One of the opinions that I really like from, and it's still good today, from Florida and from California in 2016, was an ethics opinion dealing with when is blogging a communication subject to the RPC and related attorney advertising regulations. And so the concept of this ethics opinion, and it really sort of is something that's highlighted often in California and other places as well, is you look at it and you go, are you saying you are available for professional employment? So when I look at a blog post, Okay. Are you saying that you're promoting yourself, that you're up there, that you're available for hire? And so it's the concept of differentiating between this. The same thing works for social media, right? Am I advertising, or am I just talking? Okay. Am I giving you information, or am I selling? And so that's what California does. They'll look at it and go, you're selling. Okay. So now it's an ad, and now you have to follow the ad rules. Or no, you're just giving me an article, a client alert. You're giving me information. And so the differentiation between, whether or not content is marketing or not is sort of addressed in this opinion from 2016, which again is still really effective, which lends itself to the whole concept of content marketing. And so content marketing is a huge buzzword today, right? It's not just a buzzword, it's really the way that we often market. And so when I talk about having trouble getting across to someone because I can't get a TV commercial in front of you, that's the way a lot of things work in marketing, whether it's legal or any other type of product advertising, is that our focus is often on content marketing. And content marketing often takes us outside the realm of advertising and into the concept of providing content. And so one example I have up here on this slide is the symbol for a podcast. So is a podcast advertising? Sometimes, right? Like if your law firm creates the podcast, promotes the podcast, puts it on their website, posts it a bunch of places, okay, that may be considered in some capacity under the advertising rules. If you are a guest on a podcast, which is often considered more editorial in nature, okay, like you being a guest on that podcast, that's not going to be considered advertising. If your law firm pays someone for you to be on the podcast and you are sponsoring the podcast, then perhaps it falls into the advertising realm. So when I've reviewed podcasts, all these different types of podcasts for law firms, I often tinker with the language of the intro of the podcast, make sure the disclaimer language is in there. I look at the way the podcast is promoted on the actual page itself. And I listen to whether or not I feel like the attorney's giving legal advice, possibly crossing the line. So that's the concept of a podcast in terms of content marketing. One other example I give up here, an old slide, deals with someone writing a book on winning personal injury cases. And the reason that I put this particular book in this slide up here is that this guy got a case from that Amtrak crash in Philadelphia by virtue of a family doing Google searching, finding this personal injury book, feeling like this guy wrote the book on PI, I'm going to go to him. And so again, it's the concept of taking the book, putting it out there, and then being seen as an author, being seen as an industry expert. Below, you see my promotion for this program right now. Okay, so right now, this is content marketing, right? I'm doing it right now. Okay, so, and this is great content marketing for Justia, and it's great content marketing for MICA, right? Because for Justia, they're providing content. Okay, they're not selling you product, they're providing content. They're giving you a service. For MICA, okay, I've got an audience. I'm going to talk about an area of law that I work in and that I practice in. And hopefully you sit there and go like, that guy knows what he's talking about. And so it's the concept of content marketing. This isn't an ad. And now we do sometimes tune into programs and we're like, this is a damn commercial, right? That's not happening here and it won't. But for the most part, this is content marketing. It's not an advertisement. And then another example I have up here is an article, Archaic Rules Hobble Attorneys. This is the best thing I've ever written in all my years. I wrote this as an op-ed piece for the National Law Journal in 2009. You can Google and hit this article in 2023. I've had people call me and say, I have a question, and say, like, I read the article you wrote in the National Law Journal, and I'm like, that was from 2009. And they're like, it's still good. Okay. And so it's still good and it's still up there. And so again, this is content that creates opportunity, and it's not advertising. It's all part of content marketing. The thing I want to point to on this slide for law.com is you see the Wolferman's ad up there. That is retargeting. Okay, that means that Micah was playing around looking at English muffins probably the day before I looked on this page. Now, there are a lot of people who will think like, oh, Wolferman's is advertising on law.com. That's not what's happening. And it's not a coincidence that the Wolferman ad is redisplayed. There are a lot of law firms that use this retargeting as a technique. You've already been to their website. You've already expressed an interest in an area of law. And now here you are getting it dished up again. And so that's the concept of retargeting, but this all surrounds itself in regard to the concept of content marketing. So what are the ethical considerations that we're talking about here today? This is a slide that I've used for years. The difference is that up until probably maybe even a year ago, I would spend 90% of the time of this hour on number one, attorney restrictions. Okay, this is what you need to do. This is what you need to do in such and such a state. We talk about not wanting to create an attorney-client relationship and competence and confidentiality and making sure we avoid conflicts, right? But then those next four things that were always kind of things that I kind of threw out there quickly. Unauthorized practice of law, multi-state jurisdiction, concept of solicitation, fee sharing. I kind of throw that stuff out there. Today, this program is really more about 6, 7, 8, 9 than number one, because of the way that states are looking at marketing and advertising today. The issues have changed. And so that's what I want to talk about. When we're talking about the rules of professional conduct, the model rules, which again, vary by state, different content, different comments. But these are usually the rules I'm looking at, somewhere between 7.1 mostly and 7.5. So if I were doing this program 2 years ago for you, it would all fall under this slide. I would just have like 20 slides dealing with this subject matter. But if you're new to this area, and if you're a rookie to marketing ethics, I wanted to kind of like run through some of these things that I consider an afterthought, but you might not. Okay, so what are we talking about when we talk about basics in marketing ethics? Disclaimer language. Okay, I still am amazed that every once in a while I get to a law firm website and there's no disclaimer. You have to have disclaimer language. Depending on which state you're in, there might be specific words or sentences that that are required to have there. But you need to have disclaimer language. You need to say that you're not providing legal advice, that you're not creating an attorney-client relationship, but you might, send, if you're not licensed in a particular state, you're going to send them to work elsewhere, etc. The concept of wordsmithing, which is, again, the use of words like expertise and specialization, things that bars do look at and they do come after you for using the wrong wording, the wrong language. And I call it wordsmithing when I go through a law firm's content and go, we got to change that sentence, we got to change that sentence. The concept of deceptive and misleading, which is really kind of like the central component of evaluating a law firm ad. 95% of the time. Is it deceptive and misleading? And always the reminder that I give people that just because what you say is 100% true doesn't mean that you can say it. Okay, it can still be considered deceptive and misleading. The rules that vary regarding testimonials and endorsements. Okay, there's states where you can do them. There's states you can't. There's states where you can do them, but with additional disclaimer language. There's rules in regards to endorsements. These vary. The concept of ad approvals and pre-approvals. There aren't many states that require ad approvals anymore, but they're a pain in the neck. They're horrible. And so when you're looking for ad approvals in Louisiana, sometimes in New York, certainly in Florida, Louisiana, like again, they take time, they're costly. You have to write a check when you send in the ads, and you want to really evaluate what you need to get approved and what you don't. I already talked about the concept of available for employment, and also the concept of retention policies. Just remember, if I feel like I saw an ad and I was misled, and I go to file a complaint with a disciplinary board, and I say, I was listening to this radio station, I heard this commercial from this law firm. It was in February of 2023 during the morning drive on WIP. That law firm is required to provide that commercial, okay, the script of that commercial, and they should have a record of it. They should know exactly what commercial ran and when they ran it. So the concept of retention policies, which range from 0 to 5 years, depending on which state you're looking at. And then these all fit into the concept of, again, websites. We talked a little bit earlier about blogs and the concept of whether or not I treat a blog mostly like a website. Okay. Like I have a blog, I have a Justia blog. It's great. I'm not the greatest blogger in the world. I don't pretend I am, but I'm not doing it out of the goodness of my heart, right? I'm doing it to promo. Okay. So, the concept of whether a blog falls under advertising, I feel like it does. Newsletters might. I can do an entire hour on ratings and rankings, online reviews. We're going to talk a little bit about billboards, TV and radio, social media, all these things that come into play. And you look at the one list and compare them to the rules of professional conduct that I already provided you. So what happens let's talk about real life, right? Like we always hear these rules. Do they enforce them? Do they care? How does it really work in real life? How do you end up with a grievance letter? How do you end up in trouble in this space? Okay, now I have the consumer as number one. Consumer should actually be number four because it's the least likely person to create a grievance issue for me. Okay, the rules are really created with the consumer in mind, right? Aren't they there to protect the consumer, the uneducated person, in terms of understanding how you hire a lawyer? And so the rules are supposed to be there to protect the consumer. The reality is that consumers very rarely ever complain about any of this marketing. Okay, it's almost never. There are a couple examples that I've seen dealing with online reviews, a couple of other things, but for the most part, consumers don't complain. And the reason they don't complain goes back to that archaic National Law Journal op-ed piece that I wrote, which is that consumers know something. You know what they know? That it's a commercial, okay, that I'm marketing, that I'm advertising, that it's puffery, right? And so they don't believe, they don't look at a billboard and go, oh, that must be the best lawyer in the world. Okay, just like they don't say that must be the best diner in the world or whatever other billboard you pass by. So the concept of the consumer is supposed to be number one, but in reality, they don't complain because they know it's commercials. They know it's advertising. They know it's marketing. Okay, they know what it is. My friend Tom Spot at McGuire Woods, we talk about this all the time. He always gets so frustrated. He's like, consumers know what a commercial is. All right, so number two, the state bar disciplinary arm. Most likely the people that are going to come after you, right? Okay, and so there are proactive state bar disciplinary arms. They're reactive, and there are states that could care less. Okay, they're states where I never have seen or heard anything from them. They don't care. They treat it like I just mentioned in regards to the consumer. Oh, it's marketing, whatever. Okay, so the state bar disciplinary arm, in states in which they are potentially proactive. So where are they proactive? They're proactive in like Florida, right? They're proactive in Florida. They might go and find your ad on their own and decide that they have an issue with you. There are a number of states that are proactive about it, but they're the ones that they'll find your ad, they'll find your social media post, they'll find whatever, and they'll take issue with you. Maybe you didn't file it. Maybe you're engaged in unauthorized practice of law because you don't have an office there. Whatever it is, they might come and find you and reach out and create the issue and create the grievance. Number three, responding to an attorney complaint. That's probably, there are probably as many of those, if not more, than number two, right? Okay, so an attorney says they look, they see a competitor, they see somebody else in their space. They're like, that violates 7.2C, and they complain. So I get a lot of my clients who will, every once in a while, they'll say like, oh, look at so-and-so's website. Or look at so-and-so's billboard, or look at so-and-so's advertising. We should turn them in. And I'll usually say, like, sure, go ahead. Just make sure you don't live in a glass house. And that's what I usually say to most of them. I'm going, because a lot of us live in glass houses. So before you go turn them in, make sure your hands are not just clean, they're like super clean. Because I can probably go on almost any website of any law firm and I will find an ethical violation. Okay, most people won't, but I'll find one. I can find one. And so responding to an attorney complaint, number three, and then complaints by defense counsel and in-house counsel, which a lot of people aren't aware of this. Like defense counsel have started to use the advertising rules as ways to hit back at the plaintiff's bar, at the plaintiff's attorney on cases. It's really fascinating to see. And so they'll sit there and say, hey, that law firm that's representing the plaintiff, they violated the rules of professional conduct. Okay, their advertising is inappropriate. As a matter of fact, they shouldn't even have this matter because they used inappropriate advertising in order to get it. And so this is something that I've seen more and more from both defense counsel and often the in-house counsel on the opposite side, where they started hitting back by looking at the advertising rules and determining that you got the business or you're involved, either engaged in the unauthorized practice of law or in violation of a number of the other RPC rules in a particular state. It's a really fascinating thing to see. And then who enforces these things? State bars of the courts, sometimes consumer protection laws, every once in a blue moon, a criminal case. And then there's other external forces, right? Like other people that police the area. Okay. Like how many law firms are afraid of getting dinged by Google? Oh my God, we're going to get punished by Google, right? Like that's worse than a disciplinary matter, right? Like getting punished by Google. And so there are other external forces, the Better Business Bureau, outside of the practice of law. And different types of sanctions. You got to be really bad to get in big trouble. You know, most of the time, if it's a first offense, you fix it and you don't do it again. If it's a second offense, definitely don't do it again. You know, if you keep doing it, sometimes you're doing it on purpose. I've seen firms that do challenge the state bars. You know, now you're going to start getting yourselves into trouble. But most of the time, you know, if you haven't gotten in trouble before and it's sort of a first time thing, you know, you basically go and you fix it and you make sure it doesn't happen again. That's one of the first things I say to a lot of my law firms when we sit down is I say like, hey, have you ever gotten dinged before? Right? Like, have you ever gotten called out before? Because if you have, it kind of changes the way that we're going to look at things, but the different things in regard to sanctions. So I talked about how I used to skip over solicitation. Like, you know, I would talk about solicitation. Why? Because we know what you are and are not allowed to do, right? Like we know what solicitation is. I know I can't run over to an accident scene and start handing out business cards. I know that. I know I can't call the home of a victim, right? Like I know I can't do these things. We all know what solicitation is. But people have started to change the way solicitation is interpreted. And this is an area that's really red hot in terms of various state bars starting to change the terminology, change the way they interpret solicitation. Okay, so here's the rule. Directed to a specific person the lawyer knows or reasonably should know needs legal services. That is a solicitation. Let's compare what a solicitation looks like right now to the way it was pre-internet. And really the law as it exists today, according to the U.S. Supreme Court. Florida Bar versus Wentworth in 1995. It's really the sort of the preeminent solicitation case in which, you know, and it was basically a 5-4 decision. If you basically put this case in front of the Supreme Court today, you flip it. All right. Like the decision's completely opposite. So, but in 1995, Florida Bar versus Wentworth, they looked at it and they upheld the 30-day rule in terms of contacting people in regard to solicitation in, you know, sort of in sort of mass tort or you know, hard, you know, difficult disasters, right? So, you know, Florida Bar versus Wentworth, they basically, the Supreme Court says yes, the 30 days goes, right? And so lo and behold, like the very next year, you get the value jet crash in Florida. Okay, so it immediately puts the Supreme Court case right to the test. And what they found, as you can see in this New York Times article, is that lawyers were ignoring the solicitation ban. And so, you know, they basically were just, again, going out there, going to the hotel, contacting victims' families, all the things that happened. So that was the way, you know, those were the issues. The issues are still the same today, but they're a little bit different. So last year, ABA Formal Opinion 501 dealt with solicitation and the issues dealing with it. One of the things that I found interesting about 501 is that people found it interesting, right? Like I thought like everything I read in 501 dealing with solicitation, yes, I know, right? Like to me, it was second nature. But to some, it was a wake-up call. So what happens in 501? What do they talk about in regard to solicitation? One is that, one is that, live person, like just a reminder of what you are and aren't allowed to do. All right. So what are you allowed to do? No live person to person communication, unless you carve out one of the exceptions. That you're dealing with a lawyer, you're dealing with a family member, you're dealing with people that you have a past relationship with. Those are kind of the exceptions, which again, I consider to be sort of, something everybody knows. The key part of 501 and solicitation is dealing with, taking responsibility for the actions of others. In that ValueJet crash, like 2 lawyers that got suspended, they got in trouble because their staff were handing out brochures at the hotel. Okay. And the lawyers argued like no lawyer was ever there. Okay. Their employees were there. And so they were responsible for the actions of their employees. That's no different today, right? Like you are responsible for the actions of others, your marketing department, your employees. But beyond that, you're responsible for those third parties that you engage for marketing services. Okay, lead generation companies, digital marketing companies. You're responsible for their actions. Believe me, I know there are plenty of times where I've been told by a law firm that gets a grievance letter, they're like, "Oh, our digital marketing guys did it. I had no idea they were doing that." And I'm like, "So?" I don't care. The state bar doesn't care. It's your responsibility. It's the lawyer's responsibility. And that's sort of the key. And it comes into play because of the way that a lot of the lead gen and competition has changed. So when we talk about lead generators, believe me, a lot of the lead generators out there, a lot of them are credible. Some of them have come to me for help. But for every lead gen company that's legit, there's one that operates sort of outside the scope of the rules of professional conduct. And so you have to be really careful when you're dealing with companies and you're buying leads. And so, what is it that we're buying? Are we paying for a lead or is it something else? Okay, so paying for a lead is okay. You're allowed to pay for a lead. Paying for a client referral, not okay. You look at whether or not a lead is really a disguised referral, right? Like, is it really a referral that you're calling a lead? You can pay per lead, but not per client retained. So you can't pay for a retained client. You can pay for the lead. So one of the things that some states look at is the dollars offered. So if I give you, $500 for every lead you generate, okay, maybe I consider that credible and that's legit. But if I pay you $7,500 for every lead generated, now I'm going to look at it and go, that's not a lead. Okay, that's a referral. And so you want to look at the variables that exist there. Is a non-law firm company providing legal services? You need to look at that because there are companies that get in trouble for that. And you, by virtue of hiring them, retaining them, are now in trouble. And is there impermissible fee sharing? So these are all the things I look at. The example, by the way, that I have up here on the screen, this is an email that I received to my Yahoo email account on Camp Lejeune. Okay, one of the biggest mass tort out there right now, right? And so Camp Lejeune, I get these emails. Last call, M. Bookdahl, okay, and it's from a law firm, okay, but I never gave you permission to send me an email. I never told you can reach out and contact me. There are a lot of times that we get emails from people. A lot of times the emails are generated by lead gen companies that are using unethical means to generate the lead. And so these are all the things that I look at. When I talk to digital marketing companies, I talk to them. Sometimes I don't want to know how you generate a lead, to be honest with you. All right. Sometimes I'll be like, forget it. I don't want to know. But a lot of times I do ask a lot of questions about how these things are created and how they're generated. There was one company that I was looking at not too long ago that was bragging that they were, for lawyers by lawyers. And so I said to them, I go, well, does that mean that you abide by the rules of professional conduct? Are you saying that you're taking responsibility? Okay, I can't dole off the responsibility to them if something goes wrong, but I'll sue you. Right. So what ends up happening is, so a lot of times they'll suddenly walk back well, I can't really guarantee you this, or I can't really promise you that, but, always be aware of, what you're buying in the lead gen space, and look and see whether or not it's legit, right? So I don't really know this outfit, but it captured my imagination when I was looking at slides. Choose the best lawyer. And so again, this is generating a lead for someone. And it's not really clear. It says, how does it work on that slide? I can't really tell how does it work. I'm not sure how it works. I don't know how you get in their 5-star network of lawyers. But maybe I'm wrong, but my guess is that if I have the money to be in the network, I'm in. And if I don't, I'm not. All right. And so one of the other things that I looked at too is as I went through the intake form, which is another area that I always look at, the intake form and the disclaimer language tied to it, that has a consent to contact. There is no consent. There's no language. So I'm clicking on, I accept the terms of the consent to contact disclaimer, but I couldn't find a disclaimer. So I couldn't find the text, couldn't find the content. Okay, so I was concerned there. And I was also concerned about the ownership, you see at the bottom, of consumer financial services, as if it's almost like a consumer reports type entity. But it's not. And when I went to search for consumer financial services, that's not the name of whatever the outfit is. And so you want to look at all the things that are sort of tied to it. Again, this might be a completely, fine outfit. But what I could see and what I couldn't see bothered me, and I would not let one of my law firms sign up here unless I had a lot more information. So when you talk about how personal injury lawyers, despite all the things that we talk about, we're still the biggest advertisers going, right? So regardless of whether or not I stand by it, over $1.2 billion was spent on personal injury law last year, $206 million on mass tort advertising. One of the things about personal injury law, and the reason it's so effective when it comes to advertising, is they're usually one-offs. You're not usually creating a relationship. Like, I didn't have a lawyer before, I needed you for this, and I'm not going to need you for something tomorrow. And so the concept of one-offs creates the whole idea behind what you are and aren't allowed to do. So I live in Philadelphia. I live right outside of Philadelphia. And so Jeff Rosenbaum, who, basically is an aggressive marketer. I've never met him. I don't know his law firm outside of his commercials. They run a lot of commercials, a lot of billboards. But he's taken great offense from, John Morgan at Morgan & Morgan. Okay, so, I can't speak for him, but I think he kind of hates him, right? Like, so, they consider them competitors. They don't consider Morgan & Morgan to be a Pennsylvania law firm. And they're coming in and they're taking your business, right? They're a marketing engine. And so he ran like this billboard where he just puts up John Morgan's picture and says, Florida lawyer, not licensed in PA. And so it's a highlight of the way that the market's changed and the sort of the competitive nature of the market. So how does the market change? Yeah, I don't know Morgan & Morgan. I've never had any personal interactions with them. I've met them at a couple of conferences, some of the folks. But they're a huge marketing machine, right? Like they're all over the place. I don't know if they're in every market in the country, but they certainly seem to be. And they generate leads and they generate clients, and they know where you're allowed to practice and where you're not. They're not sending, the John Morgan in Florida is not touching the case in Pennsylvania. There's somebody in the Pennsylvania office, right? But the concept of Morgan & Morgan and there are other law firms that sort of take that national scope and sort of eat away at market share. There's a very well-known divorce law firm that markets nationally and have ruffled feathers in a number of states because, again, like they're taking market share away from locals in various places. So that's one area of competition that we've had to kind of deal with and interact with. Then the concept of the virtual law practice. So this is a virtual law firm. So when you have a virtual law firm, what rules of professional conduct are you following, right? Like all of them, none of them, some of them. And so I had a virtual law firm call me, and I was looking at their website and I was talking to them and I said, you list 15 offices. It says here are 15 offices. Now the 15 offices are really 15 most likely individuals in 15 different states that handle these corporate matters. I said, but the way it's set up here, like you need to abide by the RPC for those 15 states. Like, did you send in your ads for pre-approval and for the stuff in Florida? Like, and so they, and I can tell you, like, they had no idea what, either they were ignoring it or blinders on, whatever. But the concept of virtual law practice really sometimes creates sort of an uneven playing field, because if I have to abide by all these rules and the things that I do, like, why don't they? And they're licensed in whatever state. So that has increased competition. And then competition outside the scope of other lawyers. Okay, so those are examples I just gave. Those are other lawyers. But what about non-lawyers offering legal services? And so you've probably read about the world's first robot lawyer, because they've gotten in lots of trouble of late, from Do Not Pay. And Do Not Pay was trying to say, like, you don't need lawyers. Like, we can basically handle everything for you in your suit. And that doesn't really go well with within our profession, when people tell you you don't need lawyers anymore. And so they actually were promoting that they were going to have a robot lawyer actually represent someone in court. And that never happened. But now there's a proposed class action lawsuit claiming that Do Not Pay has been practicing law poorly and lacks a license. So the complaint argues, unfortunately for its customers, Do Not Pay is not actually a robot, a lawyer, nor a law firm. Do Not Pay does not have a law degree, is not barred in any jurisdiction, and is not supervised by any lawyer. So that's the class action in California that's going on, that was just filed recently, I think last week. But there are a lot of entities that are out there that are trying to basically practice law without a license. And so that becomes part of the competition that we have to deal with. And so that lends itself to what I said, earlier about Model Rule 5.5, which deals with UPL and multi-jurisdictional practice. And those are the areas that are mostly getting hit when there are grievances regarding lawyer advertising. You're not authorized to practice law in this state. Okay, you're not barred here. You don't have an office here. And so the whole concept of, multi-jurisdictional practice. So if you want to read a really dense article I wrote in Law Practice Today, there's a screen capture. It's a point counterpoint dealing with, whether 5.5 will actually be changed to allow you to be licensed in one state and practice in all. I've said that'll never happen. It certainly won't happen. I don't think it'll happen in my lifetime. I'm not sure it'll ever happen. But it lends itself to the concept that, most of the things that we practice in now are multi-jurisdictional. They go across the board, and it becomes very hard to figure out where you need to be licensed, where you need to care about a license and rules, and where you don't. There's also just recently, earlier this month, Formal Opinion 5.0 dealing with choice of law. And again, that sort of plays into the whole concept, same as unauthorized practice of law and multi-jurisdictional practice. What rules come into play? Who's in charge here? Let me go back quickly to explain, to tell you a little bit more about, multi-jurisdictional practice and, and the way it comes into play. So when a law firm has me review their marketing campaign, what am I looking at? I'm looking at what jurisdictions I have to care about. Like, do I have to worry about? And so I look at that. I look at whether a law firm has an office in a particular state. I look at who's licensed in those offices. One of the things that's often very difficult for state bars is it's hard for them to go after someone who's not licensed in their state. So it's very easy to sit there and say, like, so I'm in Pennsylvania. All right. So say I violate the rules of professional conduct in Michigan. Okay, and somebody files a grievance against me in Michigan. Michigan can't really do anything to me, okay, for the most part. Okay, they can then take the grievance and send it to Pennsylvania and say, hey, Mike is violating the RPC in Michigan. And so Pennsylvania would then likely investigate. Doesn't have necessarily the same impact, but it's very hard to enforce the rules in other states. It's also hard to enforce the rules against these companies that aren't members of the bar. So, for example, that class action suit for Do Not Pay, you would sit there and think, like, why doesn't the disciplinary board just shut them down? Because they're not lawyers. Because there's no lawyer to go after. So you always want to think about all those things. The other thing too is when I going back to the concept of the lead generation and lead gen, is that there are a lot of law firms that are out there that they're built just to generate leads. They're not even built to practice law. Okay, I was on a site in the last couple of weeks where I found it very remarkable. I went through the site, I couldn't find a single lawyer's name, and I couldn't find a single bar admission or location. Like, it was purposely vague, right? And so when I really looked deeply, sort of at the site itself, I kind of realized like it was really there just to generate leads. Was it really a quote unquote law firm? Yes, it was. Did I track down a lawyer tied to it? Yes. I looked him up, looked to see where he was licensed, looked to see if there were any disciplinary matters. But a lot of times these sites are purposely set up to not to not be able to figure out what state you're in, where you're licensed. I recently helped someone in a very niche personal injury practice out west, and they were really frustrated because they looked at the people that had the law firms that had the greatest market share in this niche. Their websites, I could tell you, had 100 ethics violations. They were engaged unquestionably in the unauthorized practice of law. I'm sure they did not file ads in the various states that they were going after business in. All these things. Yet they've probably operated in the same way for many years, and they probably will continue to operate in the same way for many years. And so that becomes really difficult. And so that's one thing that I always like to tell people about the rules and sort of the way that I approach them, is that I'm not a letter of the law guy, okay, because the states aren't, right? Like, and so, it becomes really difficult when you're practicing in a space or you're marketing a space and that nobody cares about the rules, or that others are flaunting them. And so these are all the things that sort of come into play. So just I have slides at the end in case I ran short. I never run short, right? So, a couple of things I want to point out real quick. Here's a recent ethics opinion in South Carolina dealing with expertise.com. Again, this is a website called expertise.com. You're not allowed to call yourself an expert. Now, if you go on expertise.com, there are lots of law firms that are listed for practice areas. They did not ask to be listed. They did not pay to be listed. So if you're listed on there, you do not get in any trouble. You are not responsible for that content. But if you paid to be on there, you are. And so, keep in mind that that's the concept of proactive engagement. When you see things on the internet that are tied to you, you weren't responsible for them, you're not going to be held accountable. Trade names, another area that's changed. Those trade names are now pretty much allowed across the board, thanks to Law HQ and their various lawsuits. And so, so if you use a trade name, it used to be that you had to be careful because there were states that you weren't allowed to. Now trade names are pretty much allowed across the board. I could talk for an hour to this slide on ratings and rankings, just off of the New Jersey opinions. But again, different rules that come into play in regard to the use of ratings and rankings, methodologies, disclaimer language, etc., that come there. And then same thing with Google reviews, the power of a Google review. Not just, the content itself, but also just the numbers. As you know, like the more reviews you have, the higher you go up in the rankings. And so the concept of a Google review, I can talk about that for an hour too. So recent model rule changes that we've talked about, they deal with technology, competition, cross-border, trying to be uniform, trying to make it more simplified. Yes, sometimes you do, sometimes you don't. And looking at public policy in terms of changing components of 7.1 to 7.3. And then if you love this stuff and you're just fascinated by it, okay, I invite you to go look. These are two handbooks that are available, on the websites of the Florida Bar and the Louisiana Bar. You want to scare the hell out of yourself, go print out one of these books and go through it and try to figure out how you would ever comply with the rules in these particular states. They're great handbooks. They're really extensive and they're really thick. But when I read them, I'm thinking like, I'm not sure how I'm ever going to comply. And they're very difficult. And if you're really interested in digging even deeper, the Louisiana State Bar actually puts their filing system up online for anybody to see. And so I can basically go and look at everybody's ads that they've submitted for approval or pre-approval. And so not only can I see what gets rejected, but I can see what my competitors are doing. And so, I don't like this. Like if I'm a marketer, I don't like being able for my competitors to be able to go see everything I filed and know what's coming down the pike or what I have out there. So it's a fascinating area, the concept of the advertising filing search. And that's my hour. I don't know, Nina, if we have do we have any questions?
Yeah, we do. Thank you again, Micah, for such a great presentation. We will now move into audience questions. Okay, so it looks like we already have a few audience questions. Just a reminder, if you have any questions for Micah that have come up during the presentation, you can submit them through that Q&A button at the bottom of your screen. But we can go ahead and jump right in here. Our first question is going to be, although states vary in terms of ethics rules, what are some general guidelines that apply to most attorney websites?
Well, I'd say, I start by, what I referred to earlier was like the disclaimer language, making sure that you have the proper disclaimer language out there, the concept of deceptive and misleading when you're looking at the content, not using terminology like expertise and specialization. Another area that people get in trouble for is they call themselves like the leader in healthcare law, and you're not allowed to, okay, because no one decides who's the leader and who's not. And so, so looking at those variables. And then really, I'm always be careful. And I didn't bring this up earlier, and I want to throw this out there. There are a lot of law firms that they submit ads thinking that they're being extra careful. And so they submit ads that they should never have submitted, right? Like, so they basically put themselves under the umbrella of a state in which they didn't need to. And now they get their ads rejected, and they got to make all these changes. And now they've told that state, like, we think we're working here. And so there are times where, again, like, just be careful, make sure that you really do need to submit things to a particular state, before you do so, because otherwise you can kind of make life a lot more difficult for you by accident, and you're trying to do the right thing.
Thank you. Our next question is going to be, to ensure compliance to the rules and regulations, is it recommended for smaller firms to set a budget for hiring marketing professionals instead of doing legal marketing as kind of like a DIY in-firm thing?
I mean, I've met a couple lawyers over the years where they love to do the stuff themselves. They're really good at it. It's a lot of billable time. My wife always likes to say to me, like, how much is your time worth? How much was that worth? And so, most of the time it's not worth my time to do it myself. And the other area too is that this area, we just talked about the ethics stuff, but on like in terms of the Google side of things and all the stuff that like Justia does for you, it changes so rapidly, that something that's true today is not necessarily true tomorrow. And so I can't stay up to date on those things, so I need someone who can. And so it's really important, because again, like, the stuff changes so rapidly that I'm going to rely on an expert to be able to do those things. And especially if you're a small firm, like I don't personally, like, when I'm doing marketing projects, I don't work really well with really small firms because I need too many resources on the law firm side in order to be effective. And so a lot of times it just makes more sense to farm it out, and and then just follow those those ethics rules I talked about in terms of making sure they're doing things the way they're supposed to.
Hey, it looks like the last question we will have time for today is going to be, what are some common ethical challenges you've run into in your marketing experience, and how did you handle it?
Yeah, I think it's really determining what states you're going to fall under. I think for a lot of law firms, especially in various aspects of the personal injury space, where you're trying to market, like a lot of I have a lot of firms, they want to market into 50 states, and so the question is, like, how do we how do we comply, or how do we not comply, and how do we sort of present or position ourselves? And so, that's probably the most difficult part, is like identifying, when a firm sends me a project, and it's usually, when I talked about fast mover advantages, one thing I didn't point out too is that a lot of my law firms, when they send me something, they're like, we need this turned around like right this second. Okay, like, because we got to beat other law firms. Like, we have this class action. We got to beat other people to the punch. And so I need you to turn this around so we can get it out. And so, so I'll look at it, and I'm always kind of hoping that it's a bunch of states that aren't problematic for me. But if there are states that are problematic for me, then it can take a long time for me to sort of evaluate the specific nuances that are required in that state. And so, and I'm always looking, to see if there was a recent change to the rules of professional conduct in that state, if the RPC changed. I look at the date last updated, right? Like, I look at when the dates changed. I look to see if there are any recent ethics opinions kind of tied to the subject matter. Because again, like, something different could have happened yesterday. And give me a different answer than a week ago.
Well, thank you so much, Micah, for all of your insight and answering those questions. And thank you all for submitting your questions. It looks like we're almost out of time for today, so I'm going to hand things back over to Marina to wrap things up.
Thanks, Nina. Thanks, Micah. And thanks to all of you for being here today. We're so glad that you were able to join us. If you have any other questions or you need to contact us, please go to support.justia.com and you can submit those to us there. And have a great rest of your day.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.